Good afternoon, everyone. Welcome to our webinar on GP premises, an introduction to the legal issues of property management for GP practices. We're delighted that so many of you have joined the session today and hope you'll find the presentations and the discussion afterwards to be useful and informative. I'm David Elvin, Queen's Counsel. I'm chairing the session today, joined by my colleagues David Locke QC and Justin Bates, who I'll introduce in a moment. Just a couple of housekeeping points to begin with. All microphones other than the speakers are automatically muted, so you don't need to adjust your local volume settings. We very much welcome questions throughout the session. Please submit them using the Q&A button on your screen, either at the top or the bottom. We'll try and answer as many questions as we can in the session. And if not, if there are many outstanding questions left, we'll circulate responses to those if we're able to after the webinar. If you find that you lose your connection at any stage during the webinar, please rejoin the meeting by clicking on the original link once again. I'm going to begin with some brief introductions. Firstly, I introduce David Locke, who is speaking first. He is one of our most eminent silks, practicing in public law, specialising in particular in healthcare, pensions and related matters. He's the author of the, I'd say marvellous, because it saved my skin on several occasions, NHS Law and Practice, along with other members of Chambers, particularly Hannah Gibbs, and is the author of the Landmark Guide to Police Pensions. He, after an early career as an MP, he has resumed practice and is now a Deputy High Court Judge sitting in the Queen's Bench Division and Administrative Courts. He is also, in a strange sort of way, trying to cycle to Australia. It's taking him some time, as you can imagine, and I'm pleased to say he's doing it in segments and not all at once. I'm going to let him start his paper now. But before then, I'll just briefly introduce Justin. Justin is a housing and property specialist, also dealing with public sector housing, local government law. He's the deputy editor of the Encyclopedia of Housing Law and the co-author of a number of works, including annotations to statutes. He has a high public profile in terms of advice to parliamentary committees and to various other bodies. He is one of the few barristers who've been appointed to the Equality and Human Rights Commission Panel Council and has taken an active role in news and current affairs in dealing with matters of concern in his areas of practice, and in particular the right to manage reform proposals introduced by the Law Commission a year or so ago. So we'll begin with David and then move on to Justin. David.
Thank you very much, David. It's a pleasure to be here. Thank you everyone for attending and for your time. The purpose of my talk is to describe the legal arrangements which lead NHS GPs in England to receiving money from the NHS to meet the cost of their GP premises in what is a fast-changing environment for GP practices. I've only got about 20 minutes, and according to this talk, can only scratch the surface of a reasonably complicated matter. But I'll refer to the problems that arose in a case called Sawolsky in NHS England, which went to the Court of Appeal in 2017, to explain how getting the framework right is essential in order to understand what you can claim, what you're entitled to, what you can't entitled to. GP practice models have been reasonably consistent in the NHS since it was founded in about 1948. Namely, each GP practice is a separate legal entity, either a sole practitioner, partnership, or a medical company, serving the interests of the patients on the GP list. And GPs cooperated with each other. They were members of the same LMC, but not as a matter of professional obligation, not as a legal obligation. And the traditional model was that the doctors that delivered the services to the patients owned the business within which the services were provided. Now, a combination of changes to government policy, the pandemic, changes in the way doctors see their role, wider society, have meant that the model for delivering primary care services is rapidly changing. And those changes will have a substantial effect on the way that GPs operate their premises. And those changes were summarised in a background paper, a General Practice Premises Policy Review in 2019 from the government. I think it's fair to say the pandemic has diverted everyone's attention since then. But as we move, hopefully, into a post-pandemic NHS, those issues will come back to the fore. So what are the drivers of change? It seems to me that they are the 6 I've put on the screen there. Firstly, and perhaps most importantly, the government's desire to move substantial amounts of medical care from acute trusts, from the hospital setting, into primary care. What GPs are going to be required to do in their practices is going to be substantially larger in the years to come. They'll need more staff, they'll need more premises, and there'll be more people, more patients coming through the doors. The second problem, which is driving change, is a national shortage of GPs. Full-time equivalent GP numbers are falling at the same time as GPs are being asked to do vastly more. And promises in the past to recruit extra GPs have not actually led to FTE numbers growing. Thirdly, there's a marked reluctance of younger GPs to take on ownership of the business, but premises in particular. And that's part of a wider reluctance amongst GPs to run a business. What they really want to do is to deliver professional medical services rather than being small businessmen and small businesswomen. And that's having a profound effect on the traditional GP model. We see the merger of practices and different practices moving to operate within jointly owned or jointly rented premises. We see the move to contracting away from the individual GP practice towards primary care networks, DES service contracts, which emphasize contracting across a region, across a network area, not just with an individual practice. And finally, and perhaps crucially important, there is a move from in-person communication to digital consultation. And as a result of that, what GPs do is much more digitally based, and they were doing it on the telephone, they're now doing it on Zoom as we are talking today, in a way which is profoundly going to change what they need in terms of not only technology but buildings. So all these developments will affect premises, but there's nothing in the Health and Care Bill, which is presently before Parliament, to suggest that the arrangements, the legal arrangements for GP premises or contracts are going to change. And therefore we have to assume that this changing environment is going to take place within the existing statutory framework. So what is the framework? Well, we start with primary care services being governed by Part 4 of the NHS Act 2006. NHS England has a statutory duty under Section 83 to provide primary care services to such extent it considers necessary to meet all reasonable requirements. NHS England meets that statutory obligation by entering into arrangements with individual partnerships and medical companies, which together are referred to as contractors, under which the contractor agrees to provide NHS primary care services to patients of the practice and limited categories of other patients. The contracting arrangements can be hugely complex now because the traditional model of individual autonomous GP practices is giving way to GP federations and primary care networks. But the model of the standalone GP practice, whilst it's out of date, that's the framework which still exists for the legal arrangements. Accordingly, you can very often now, there are collaborative arrangements which govern what GP practices do, but the underlying commissioning contract is still there with the individual GP practice. Now, the way that the powers are constructed is at best a statutory curiosity. Section 83(2) gives NHS England wide powers to decide who should hold a contract to provide primary medical services and the terms of the contract. It provides the board may, in addition to any other powers conferred on it, make such arrangements for the provision of primary care medical services as it considers appropriate, and it may in particular make contractual arrangements with any person. And section 84(1) then gives a specific power to NHS England to enter into what's called a general medical services contract, or a GMS contract. And section 89 provides that where NHS England does enter into a GMS contract, that contract has to contain such provisions as are prescribed in regulations. Thus, having been given a general power to enter into any form of contract it likes, it's slightly curious that NHS England is then given a power to enter into a specific form of contract, the form of which is mandated by regulations. Frankly, the answer as to why that happens lies in history, because GMS contracts are the successor of the General Medical Services arrangements that existed before there were contracts starting in 1997 and then becoming more common from 2004 onwards. So the GMS contract is the evolution of the former GMS arrangements, which provided for a statutory payment scheme for all GP practices. And as it was a statutory scheme, there was no contract. But in practice today, the GMS contract is the default form of contract. And after flirting with multiple forms of contract between 2004 and 2013, there's now been a general move to put GP practices back onto GMS contracts and a move away from other forms of contracting arrangement. But before looking at GMS contracts, it might be helpful to look at the statutory provisions which underpin the second most common form of contract, which is a PMS, or a personal medical services contract. And that's a contract under section 92. That provides that the board may make arrangements other than arrangements under section 83(2), that is other than the general power, where it does make those arrangements have to comply with section 94, and section 94 refers to a regulation making power, and those regulations are the National Health Service Personal Medical Services Agreement Regulations 2015. So in practice, there are three forms of contract for GP practices. There's GMS contracts, that's the standard default form, PMS contracts, which are becoming less common, but are still in existence, and then what are known as section 83(2) arrangements, also known as alternative PMS contracts, alternative personal medical services contracts, and that's the form of contract which tends to be used when an NHS body, such as an NHS Foundation Trust, takes over a GP practice and employs the GPs in the same way that hospital doctors are employees. And the payments for premises operate differently under the different contracts. The other point to note at the beginning is that there are two forms of NHS contract of arrangements, an NHS contract and a legally binding contract. And section 9 of the NHS Act set up the NHS contract as a form of service level agreement between different NHS bodies, and in order to ensure that NHS bodies didn't sue each other in the courts when they had a dispute resolution process was arranged, under which the Secretary of State appoints an adjudicator. That role is now undertaken by the National Health Service Litigation Authority, or NHS Resolution. If there's an NHS contract, there's an absolute bar on litigating the arrangements that arise out of such a contract. And an authority for that is a case I did in 2014 called Pitalia and NHS England. Decisions by the NHSLA in the exercise of their functions for the NHS disputes resolution adjudication are subject to judicial review challenge. An authority for that is the Hussain case, which is referred to on the slide. And a recent development, quite an important development on primary care contracts, is that now when an award is made, the Court of Appeal recognised in a case I did in November last year that it's appropriate also to award interest. In that particular case, I was acting for SSP Health. The amount they were owed was determined to be about £500,000, 560,000. It was over a long period, and they ended up with £230,000 worth of interest. So that was quite an important development. Now, if one has PMS contracts, the rule is that although there is the ability for the Secretary of State to make directions defining how premises payments are to be made, no such directions have been made. The authority for that will be under Section 98A of the NHS Act, but in fact, no directions have been made. It follows that the amounts paid to a PMS contractor depend on the terms of the contract. Now, some of these contracts say the premises payments will be the same as you would have if you had a GMS contract, and I'll come on to how it works with GMS contracts in a minute. Others say that this is the amount that you'll be paid either inclusive of payments for premises, or the amount you get paid for premises is a fixed amount. How those principles worked out was looked at in a case called Savolsky, and the facts of that case were that the GP practice entered into a PMS contract with premises payments of about £77,000 a year, and that was fixed because that was the amount they were paying under a practice loan where the interest rate was fixed for 10 years at 8.87%. When that period of that high interest rate ended, they carried on being paid premises costs at £77,000 a year. NHS England said, hold on a moment, 5 years later, we only fixed those payments because that was the amount that you had to pay under the interest, and we've effectively been overpaying you for, I think it was 6 or 7 years. The doctors said, well, we're quite happy to change it from now on, but you can't claim it back because we've spent it on patients and we've spent it on practice and we've invested it back into the NHS. NHS England didn't accept that and sued and failed, because in the end, the court decided the contract meant what the contract said. In other words, it was a payment of £77,000 per year. And therefore, the answer was to amend the contract, which is what the GP practice had always been doing, offering to do, but you couldn't make a retrospective claim. Now, the human cost of that litigation was potentially enormous, because by the time we got to the Court of Appeal, the original partners had retired. The amount claimed was something in the region of £1 million, and that would have left them in penury for their retirement. But as it was, they won, so it wasn't a problem. But the message from this case, seems to me, is that premises payments, certainly for PMS contracts, are governed by the terms of the contract, not by the sums that would be payable if this was a GMS contract. We then move on to the question of how do the GMS payments work, and here it's wholly different. Payments in respect of all GMS contracts are governed by directions made by the Secretary of State, and the statement of fees and entitlements is a detailed statement of the fees that are payable to GMS contractors, and it's subject to annual negotiation between the BMA GPs committee and the government, and is tweaked sometimes annually, sometimes biannually. But in terms of premises costs, there are specific directions made by the Secretary of State. The Secretary of State is entitled to make directions under the NHS Act. Once you make directions, that becomes internal NHS law, and you have a legal right to be paid the sum on the directions, because the contract states that the sums payable are sums as set out in the directions. It's set into, the directions document is 30 pages long, and it contains 6 parts, which I've set out there on the slide. Part 1 is a series of general provisions, including provisions relating to payment in circumstances where the directions don't apply, and giving NHS England a general power to make additional payments, but it's a power, not a duty. Part 2 governs the grants which are available for premises development and improvement. And on this call, there are many people who are far more experienced in development processes to build new premises, to redevelop premises for GPs, and understand the complex processes that need to go through to get the grant approved and then paid. Part 3 governs professional fees and related costs where GP practices occupy new or refurbished premises. Part 4 is grants relating to relocation or remortgaging by the contractor. Part 5, which is the part that it tends to be most relevant to the day-to-day practice of running GP practices, is recurring premises costs, which I'll say a bit about in a moment, and then there's some miscellaneous provisions. Now, there's insufficient time today to go through all the details of these directions, and you'd all fall asleep if I tried to do so. But the case law from the appeal authority guides where there are disputes and gives an indication of the meaning, because as with every statutory framework, the meaning of the provisions in the directions is a matter of law, not a matter for the interpretation of NHS England. And some of the wording in the directions has been subject to considerable dispute. So I'm going to confine myself to making a series of general observations about how the directions operate in respect of recurring costs, because that's the area that, as a barrister, I tend to get involved, as opposed to the development, non-contentious side, where there are, as I say, there are real specialists. First, the general scheme of the directions is to ensure that practices are reimbursed the cost of operating an appropriate premises that meets NHS standards on a year-by-year basis. And historically, GP practices have operated as partnerships, where the incoming partners buy into the capital owned by the business, and the outgoing partners sell their capital interest to the remaining partners. And GP practices, of course, NHS GP practices cannot sell the goodwill of the business. That's prohibited under Section 259 of the NHS Act. But a retiring GP can still expect to part fund his or her retirement by selling their share of the practice premises to the continuing partners, or alternatively, if they retain the interest in the building, to continue to receive payment by way of rent or notional rent from the practice premises. So that's the background to the concept of notional rent in paragraph 41 of the directions, which is where the GP practice owns the property, so the contractor owns the property, and therefore premises payments are paid on the basis of a notional rent set at current market value, as determined in accordance with parts 1 and 3 of Schedule 2 to the directions. And those payments are subject to basically a 3-year review, but that review can be brought forward. Schedule 2 provides that the current market rent must be fixed following recommendations made by the district valuer, who's tasked with determining a rent which might reasonably be expected to pay by a tenant for the premises at the valuation date. Now, the regulation or the directions provide that the fact that the rent will be paid on directions is required to be ignored. But that in practice causes a difficulty for dedicated GP premises, because very often these are premises of a type that are specifically designed for a GP practice but don't have any obvious alternative use. And therefore, how do you fix the rent for a premises where you're required to ignore the fact that there's a statutory framework to pay the rent, but there is no other source of income to pay the rent? The answer is this is a matter for surveyors to do their very best. But an example of how it works in practice is shown in a recent NHSLA case, which is 22176. And in that case, the GP contractor claimed notional rent for premises he owned of £69,000 a year. NHS England was only prepared to pay £57,000 a year. The district valuer had looked at it and advised a notional rent of £63,000. But NHS England said no, that was overvalued. They didn't accept the district valuer. And on appeal, what happened is the NHSLA appointed their own surveyor who recommended 65,000. And unsurprisingly, the adjudicator went with the 65,000. So the answer to that case was that it was that the adjudicator came some way down between the figures of the GP and NHS England, but in fact considerably nearer the value of the GP. Secondly, as an alternative to notional rent, GP practices can say that they want to be paid what are called borrowing costs. And the underlying principle is that a GP should not be entitled to borrow money and buy and improve premises to bring them up to NHS standards and then make a profit, but the GP practice should be entitled to recover reasonable interest for the costs of a premises loan. But the sums payable as borrowing costs are not necessarily the same as the costs payable under the loan for the development of the premises for two reasons. First of all, as I mentioned a moment ago, borrowing costs only applies to interest payments. So if the GPs are paying off the loan and thereby acquiring a capital value, they have to fund themselves the cost of acquiring the capital value that will then be accrued to them. And that seems perfectly reasonable, because why should the state fund the capital acquisition of a property, whereas one can perfectly see why the state is effectively funding the revenue costs. But secondly, the percentage payable is fixed by paragraph 38A of the directions as effectively being the lower of either the sum payable under the agreement or borrowing costs fixed under a formula. So GPs have a chance of losing out even on the interest rate, even on the revenue cost of the interest, if they negotiate an inauspicious loan. So lastly, GP practice can lease their premises and pay a landlord, and then they have to pay the actual lease rent. So these are all cases, these are all issues for those advising GPs. It shows how it is can be complicated, but for GMS practices, it's all about the statutory construction of the 2013 regulations. I'm sorry if that's a quick jolt through. I hope it's been helpful.
David, thank you very much. Just before bringing in Justin, before I forget, could I just ask you to note that in the chat, you've been sent invitations to subscribe to our new monthly newsletter on health and social care, and we hope you'll be interested in signing up and joining the subscription to the newsletter. Thank you. I'm now going to hand over to Justin.
I should immediately explain by saying I am not wearing sunglasses, despite it may appear that on your screen. One of the things I've discovered over the 18 months or so of being locked down is that the angle at which the sun strikes my face here in the attic of justice, where I've been stuck for the last 18 months, means that it looks like I'm wearing sunglasses, and I promise you I'm not. I prepared for today's talk by spending a couple of evenings reading GP blogs and GP Twitter, which is a surprisingly interesting thing to do. And all the things I'm going to talk to you about in the next 20 minutes or so are things that have actually, I came across in real life, as it were, on the blogs or on Twitter. They haven't all happened in one building at any one time. That would be quite an unfortunate series of events. And I'm going to base it around a photo of a GP's building that's just down the road from where I live. But let me immediately say, because I know there are some GPs on this call, that I have no knowledge at all of the building that I'm discussing, aside from the fact that I know it exists and I know there's a GP's practice in there. I don't know how its title structure works, and I don't know whether any of the users of the building are doing any of the things I'm about to discuss. So if by chance my GP is listening, I have no idea if any of what I'm about to say is relevant to you or not, but your building is a really nice way to explain some of these problems. So just up the road from my house, here we go, a relatively new build building which contains a GP's practice. It's about 10 to 15 years old, but as you can see, it's not only going to have a GP's practice in it. So if I use my my mouse here so you can see, the top floor there with that wooden effect, which we'll come back to in a moment, those are flats, maybe 20, 25 flats. We've then got the next layer down, office space, some of which is tied to the various GP's practices, some of which is used by individual businesses. The next layer down is where we have two different GP's practices, one at the front and then the other one you can't see is at the back of the building. Over here on the right hand side, just over there, you've got a pharmacy, and then down at the ground level you've got a little road taking you through to a car park which goes underneath the main footprint of the building and extends to a rear car park behind it. So you can see a bit more of it here with a slightly less impressive photo. So again, you've got the flats, office space, one GP's bit in here, another GP's bit round the back. There's the pharmacy, which is in the same floor as the GP's. There's a cafe. Just over there, if you can see, there's looks like an indented area. That's the exclusive entrance for the flats and the office space. And that obviously there is the entrance into the GPs and into the pharmacists. So a fairly regular, I would suggest, commonplace mixed-use building. So what have we got there? So there you go, the top part of the flats with some cladding. I'll come back to that in a minute. Then our office level, then two GP surgeries and a pharmacy, cafe, car parking at ground level. Some of the car parking is private. Some of the car parking spaces go with the flats or go with the surgery or go with the office. Some of it's public. There's a local authority controlled car parking scheme there as well. You've got the independent access to the flats and the office via their own staircase and their lifts. And somewhere in that building, although I confess I don't know where, is going to be a fairly complicated plant room to deal with pumping water and managing electricity throughout the different use classes there. How that building is set up is probably something as follows. There's going to be a freehold of the whole of the building, probably, although nothing really turns on this, probably held by a public authority. It looks to me from the surrounding area that it's probably county council or district council land it was originally built on. There's then going to be a head lease of the whole building, which will include all of the different areas that end up with different use classes. It'll have the car park in there as well. That's probably held by some commercial party because it's a relatively valuable head lease. The rents under these leases are going to be quite significant. So, for example, you wouldn't be surprised to see something like a pension fund, an Aviva type, own something like this. You're then going to have under leases of certainly the GP's surgeries and the pharmacy, and probably the cafe on this analysis as well. The under leases will be for varying terms, and they'll be on varying durations, and they'll be on varying terms as regards payment of rent and payment of service charges. Some of them will have car parking spaces and some won't. There's also going to be an under lease of the office floors, which presumably have some of the car parking spaces as well. And you imagine that out of the office floor under lease, there'll probably be sub-under leases of individual parts of the offices, because that's a fairly big office space for one company to hold and occupy. The part of the country this is in, there probably isn't a single company that's big enough to hold all that space. It's subdivided, I would have thought, into 6 or 7 smaller offices. And as a result of the pandemic, one of the things that's happened recently is that we've now got some individual licenses being granted as parts of the office. So a company who had taken the space to use as their office, the company no longer needs as much space, and it's renting out individual desks on a WeWork style analysis, WeWork style arrangement. And then you're going to have another underlease in respect of the flats. So there's probably one underlease of all of the residential area, and then you've got sub-underleases of each flat. For some of those sub-underleases, there'll then be a further tenancy, which will be the occupational tenancy, where it's rented out on rack rents, so short haul tenancies, to the people that live there. So you've got a freehold title of the whole thing. You've got a head leasehold title of the whole thing. You've then got a series of under leases of different parts: cafe, GP surgery, pharmacy, office, flats. Then the offices and the flats have further lettings underneath them. So you've probably got 5 layers of title at this building, which is complex, but not out of the norm for a scenario like this. What kind of problems are going to arise in those circumstances? Well, the first problem that jumps off the page to me when looking at this is there's obviously quite a tension between the regulatory position of the different users of the building. So let's just jump back a minute. This photo here is the best one. I confess to some concern about that wooden stuff that's on the outside of the residential part. I would suspect that's cladding of some form. That's either going to be straight timber, or it might be something called HPL, high pressure laminate. High pressure laminate is effectively tiny bits of wood fibre that have been forced through a mixture of water and glue and held together to make what looks like a wood effect, MDF style exterior of buildings. And both HPL and timber are very popular because they win lots of prizes with architects and they look good. But there's a problem with that kind of cladding. And any of you who are doing any major residential work at the moment will know that kind of cladding is very flammable. And when one of those people with one of the leases of the flats tries to sell their flat, a problem is going to arise, because high street lenders now effectively, as almost without exception, require what's called an EWS1 certificate before they will grant mortgages for the purchase of flats. An EWS1 certificate is something that the RICS produced to describe the fire risk of a building. HPL cladding and wood effect cladding are difficulties for EWS1 certificates and probably mean you're going to get either an A3 rating or a B1 or a B2 rating. The practical effect of those is you aren't going to get a mortgage from a high street lender. Well, that's all very sad, says our GP sitting down here in this bit, which is the GP's practice. But why do I care about that? Well, you care about it, I suspect, because of how your lease is going to be set up. The usual way for all the different leases to work in an arrangement like this is that let's jump back here, either this person, the freeholder, or more likely, I suspect this person here, the head leaseholder of the whole, is going to have an obligation under the terms of the leases to all of these people here. So these people at this level, oh, come back. These people at this level, and this level, they're going to owe those people obligations in respect of the condition of the exterior of the building. And it is very likely that the condition of the exterior of the building triggers the obligations that are owed under those leases, because, as I'm sure you all appreciate, having flammable material on the outside of your building is not generally something to be encouraged. The way the service charges are likely to work is that when this person does some work to the structure and the exterior of the building, everyone at this level, and this level has to pay a service charge for it. So even though the work is going to be done at this level of the building, because that's the area with the dangerous cladding, the people at this level and this level are going to have to pay via their service charges. And as again, many of you may know from those who are doing this kind of work, remedial costs of fire safety work are very, very expensive. We have a shortage of people who can do it. We have a shortage of material. We even actually have at the moment a shortage of scaffolding in this country. I would not be at all surprised to learn that remediating just that layer's worth of wooden material, I wouldn't be at all surprised to see a total service charge bill of well over £1 million, plus VAT, plus professional fees. Now, The people at this level paying for it via their residential service charges might well find there's some government money available because there's a problem at the moment with fire safety nationally, and the government has made some certain sums of money available to assist with that. But it's only available for the residential parts of buildings to alleviate the burden on residential occupiers. It's not available for these people, or for the purposes of this webinar, these people, the GP surgery down here. So you may find that because of something up there that has no real impact on you, your service charges go through the roof because you're paying whatever your share will be of the remediation costs of this building. The other problem it's going to have, I suspect, is the last bullet point here, the impact on insurance. For obvious reasons that don't need spelling out, post-Grenfell, insurers have got very, very nervous about buildings with any kind of flammable product on them, and insurance costs have gone through the roof. It is not uncommon to see service charge increases in the multiple hundreds, if not thousands of %, because the risk appetite of the major insurers has changed dramatically. So you may well find that because of this particular predominantly residential problem, because you're a tenant in this mixed-use building, you end up being dragged into the same scandal and the same cost implications. And there's not a lot you can do about that. And the schemes that have been created to help deal with fire safety costs exclude commercial users. They only help resi users. So that's the first thing that worries me about a scenario like this. Second thing that worries me, and having read lots of GPs blogs, I know troubles lots of GPs in practice as well, is the allocation of service charges. Because this is an area where there's no real general rule. You have to go and look at what each individual lease has to say. So our GP practice, upon being told it's going to have to pay a couple of £1 million or contribute towards its share of a couple of £1 million worth of fire safety work, suddenly says, well, how much? Let's go and have a look. This can't be right. I derive no benefit from this. Well, you go and look at the lease. If the lease says that you pay a service charge based on a floor area or based on a fixed percentage, then that's the end of it. That's what you pay. That is the agreement that was signed up to, and that is how it will pan out. Whether you derive a benefit or not hasn't really got anything to do with it. So you may find that an agreement that you thought was quite attractive because you pay based on floor area and you think, well, yes, if I'm a major floor area, I should pay quite a lot towards it. What that does mean is that you might end up subsidizing something you have no real benefit from. What about if it's not floor area or not fixed percentage? What's the other way? Well, the other way is usually some sort of discretionary apportionment, discretion of the landlord or the landlord's surveyor or the landlord's managing agent, as the case may be. Now, again, in mixed use buildings, there's a particular problem that's developing here. Commercial tenants have relatively few remedies in respect of service charge apportionment disputes. It's really a question of looking at the terms of the lease, seeing what those terms are. If they provide for the decision to be taken by the landlord surveyor, then absent spectacular error or material factual irregularity, something like that, absent that kind of absolute disaster, the landlord surveyor is going to be the entity that makes the decision. But for residential users, the position is very different. The residential tenants, and as it happens, the head leaseholder of the whole building, because the head leaseholder of the whole building counts as a residential tenant because there is at least one flat in his title, they have a whole range of service charge provisions open to them. And the ones that I'm most interested in mixed use buildings are the powers of the first tier tribunal to effectively reallocate costs between user classes where they think that's the proper thing to do. So this has been a line of cases that's been developing over the last 10 years or so in the Upper Tribunal Lands Chamber, and then finally got approved in 2 Court of Appeal cases, one called Sheffield and Oliver, which was about 3 years ago, and then more recently, a case called Aviva and Williams. If you're a residential service charge payer, and your lease makes provision for the landlord or the landlord's surveyor or the landlord's agent to decide what your service charges will be at any given time. So they decide the apportionment. Then section 27 big A, subsection 6 of the Landlord and Tenant Act 1985, effectively renders that landlord's power void. And it says that in the event of a dispute, the first tier tribunal property chamber gets to decide what the allocation of costs should be. And it does that not on a review basis, not on a Wednesbury, have you taken into account all relevant factors, is your decision reasonable? They get to do that on a what would you do tribunal if you were running the building kind of analysis. And if you look at the Aviva and Williams case, it approves an upper tribunal case called Windermere Marina, which was all to do with reallocation of cost between residential users and a commercial user. In very simple terms, you've got a high-end development, flats above commercial units. The commercial units are bars and restaurants. They attract a lot of footfall. Where should the costs of cleaning the external estate go? Should they go to the residential parts in X percentage, or should it be a lower percentage? If it's a lower percentage, where should the difference go? Should it go to the commercial tenants because it's really their customers who are causing the problem? And the upper tribunal ends up concluding that the FTT property chamber gets to decide all of these questions for itself based on its own consideration as to what it thinks the merits are. So you could well see, and you do see, cases where residential tenants end up bringing their service charge disputes to the first tier tribunal, something which is A, relatively common, and B, encouraged by the way the costs rules work, because the basic position is the FTT property chamber doesn't award costs. So it's effectively a costs-free environment for the residential leaseholder. You see them going and arguing about the allocation of costs and arguing that things should go down, should move off the resi accounts and go onto the commercial accounts. So if we looked at our building here, for example, ignore cladding for a moment. Let's just think about insurance. It's very likely that this cafe here, this cafe here drives up the insurance premium for the building. Because, as you might imagine, I call it a cafe, it's a glorified kebab shop. The reality is fast food places like that do pose an insurance risk, they pose a fire risk, and so your insurance is generally higher. So you find that these people challenge the allocation of the insurance costs because they say the insurance is high because of this person here, so move more of the insurance costs off us down to him. Now, whether that works or not is obviously always a matter for the individual evidence and the individual tribunal, but that's an argument that's open to users of mixed-use properties to the benefit of resi tenants and to the detriment of commercial tenants. And again, I confess I came across a blog where this has happened to some poor GP's practice who found that 15% of the cleaning costs had got moved off the resi tenants down to the commercial tenants by an FTT decision. And I can see not just cleaning and insurance, but I can see other kinds of cases of costs that might move that way. The other thing to worry about, of course, is that where you get things like in the discretion of the landlord or the landlord surveyor, one of the things that people worry about is whether or not everyone pays equally. Now, by that I mean, these people, these GPs, they're paying service charges, the offices are paying service charges, these guys are paying service charges. But suppose for a minute this cafe cum kebab shop only has a 5-year lease. It doesn't make a huge amount of money. What it does, though, is it has an all-inclusive rent. So its rent covers all of its expenditure. It doesn't have a service charge liability as well. It would be naive beyond words to think that where the landlord is receiving a rent and no service charge liability, there is not an incentive to try and shift service charges from this user to these users who do pay for it. And again, I had an entertaining 20 minutes reading about a poor GP's practice that ended up having that fight with one of their commercial co-tenants in their building. As you'll immediately have picked up on, this is going through the service charge element of this is quite a big piece of work, and I don't envy the poor GPs or the office managers having to go through all of this to try and work out where their service charges are being padded or potentially being unfairly increased. Well, what about the third kind of problem? Because I've got one eye on the time here. The third problem, it seems to me, just comes from the fact that you have a relatively complex title structure in these buildings. The 5 tiers of title that I described earlier wouldn't be particularly unusual. You could do it with less, you could do it with more layers of title, but I don't think anyone involved in the field would fall over backwards in horror at the idea of there being 5 layers of title. And that gives rise to a number of different problems. Firstly, of course, working out where all the repair obligations sit, because it's probably going to be one of these two who have the various external repair obligations, at least, because they're the only people who've got interests in the whole of the building. But of course, if it is one of these two, or if it's this one, then the only person who can directly enforce the obligation is this person. If it's this person, then this layer, and this layer can all enforce the obligation. But what you can have a situation developing then, the second bullet point there, is that ultimately you as a tenant need to enforce an obligation that isn't owed to you by the person who's got the ultimate obligation. How do you do that? And as I'm sure everyone has immediately realized, you end up in this quite frustrating chain of litigation where you have to sue your landlord because you hope that he's got a clause in his lease saying with you, saying that he will use his best endeavours to require his landlord to comply with his terms of the lease. So you sue your landlord saying you're not using your best endeavours to make your landlord comply. He then has to sue his landlord to try and get his landlord comply, all of which ends up making things slower and significantly more expensive than it might otherwise need to be. You can also find frequently that all these leases are inconsistent. In an ideal world, all of these leases were granted at the same time, more or less, with the same firm of solicitors involved, making sure all of the leases sit together. In the real world, you can count the number of times that happens on the fingers of a badly deformed hand. The reality is different leases are granted in different forms by different people at different times. And so you might find, for example, that people have different service charge years under different leases, which makes the billing and accounting process incredibly difficult. You might find that some people have had obligations and rights granted to them that are inconsistent with what their landlord was capable of granting. So you might have a situation where, for example, this person with the underlease of the whole of the residential premises granted these people something they couldn't grant because as this person's relationship with this person up here, this lease hadn't granted the relevant right that then they purported to grant on to these people. That happens depressingly common and is one of the things that keeps people like me in business. And again, I know from reading a few of the blogs, this happened on enough occasions to trouble GPs. Finally, because I've got one eye on my time here, last thing I want to flag up is this. There have been 2 quite interesting cases in the last 18 months or so, in fact less than that, last year really, about how you do service charge challenges. Now these are of general application, they're not to do with mixed use buildings per se. But what they're doing, Criterion Building is a commercial one and GEL is a residential case. But what they've both said is picking up on an old case from the 1980s called Yorkbrook and Batten. They've said service charge disputes are a slightly different kind of normal civil litigation. If your landlord sues you for service charges, you can't just defend it by saying prove it. You've got to deal with you as a tenant have to advance some prima facie case as to why you don't have to pay these service charges. The prove it defense doesn't work. They call it an initial burden or a prima facie case. Now, how much of a burden that is in any given case, obviously one on each individual facts. But what that does mean is that if you're looking to run a service charge dispute as a tenant, particularly in a mixed use building, you're probably going to need some input from a surveyor at a fairly early stage to let you know what it is you might be able to argue. A vague feeling of it's unfair isn't going to be enough. And in particular, you can't just fall back on approve it. And I think in practice what that means is if you're going to try and bring a challenge as a tenant, you're going to need to front load your work. That is bang on my 20 minutes, remarkably. So I will pause there for a minute and hand back to David Elvin.
Thank you very much, Justin.
Wait there.
Thank you.
Yeah.
I've got a couple of questions, and the first one I'm going to field is to you, Justin.
Yeah.
We've had a question about what it says is the most common form of lease for GP tenants, which are TIR, internal repairing only leases. And the questioner says, well, what is the risk of liability for replacement for external composite panelling, say by attempting to charge for it under fire safety service charge heading, even though it could be regarded as external repairing or replacement, given the internal repairing obligations only?
I mean, a variant of this is, frankly, sitting on my desk and every other member of Landmark Chambers property team every day of the week, I would have thought at the moment. I mean, the cop-out answer is what does your lease say? The slightly more detailed answer is actually relatively few people are doing fire safety work under repairing covenants in leases, because you have two, and I'm sure our questioner knows, very often the lease just says you have to keep the structure and the exterior in repair. It doesn't matter whose obligation it is for the moment. Let's just look at the nature of the covenant. You have to keep the structure and the obligation, structure and exterior in repair. A building with flammable cladding on it is not out of repair. It is in exactly the same condition as when it was built. There's been no deterioration in condition, which is what's required for a repair. So actually, most of the cladding work isn't being done under that covenant. It's being done under comply with the direction of a competent authority. So the fire brigade or the local authority serve a notice. And then it doesn't matter so much where it is. It's comply with the obligation. Or it's being done under the insurance covenants, because if you generally find that there's an obligation to do such things as are required by your insurers, or there's an absolute duty to obtain insurance. And if you can't do that without also doing some work, then that's the route by which you do the work. So it is a good question. And frankly, a lot of people duck it because a lot of it isn't being done under any of the repairing covenants. It's being done under other provisions.
I mean, just taking the general approach to fire protection and cladding post Grenfell, the government's introducing legislation to extend the limitation period on defects liability under the Defective Premises Act. Is there any risk that a claim under the Defective Premises Act could be passed back to tenants under these arrangements, or is that really targeting at landlords?
So at the moment, the Building Safety Bill is doing two things to the DPA, isn't it? The first is it's extending and retrospectively extending Section 1 DPA liability. So anybody who's already got a Section 1 DPA right, which in broad terms means the tenant against the developer. I mean, it could also be the freeholder, but it's aimed really at the tenant. It's a claim against your developer. You're going to have 15 years rather than 6 years to bring it, and they're going to backdate it. So the plan is that anything built post 2010, you'll be able to have a DPA claim even if it's now expired at the moment. They're also going to create a new cause of action in the DPA to try and catch anyone who does refurbishment short of a Section 1 claim. So that's to catch people who've gone and put cladding on the outside of buildings without actually being involved in doing the building work themselves. So it's the refurb cases.
Yes.
So, an actual Grenfell scenario where there was a refurb that didn't give rise to a Section 1 claim. I'm not sure if that one's going to be retrospective, though. I think it is. The bit that's troubling, at least me when I read it, is there's an amendment in there as well, which says that notwithstanding the fact they've made it retrospective, the court is prohibited from granting any remedy if to do so would be incompatible with the defendant's human rights, because obviously it's retrospective legislation, and presumably there might even be Article 1 First Protocol 1 issues in there. So you can see what's going to happen. The first claim is going to the Supreme Court to figure out what that claim means.
But then it's a question of proportionality.
Potentially, yes. But the first person to bring one of these claims under these provisions is funding the claim to the Supreme Court to find out what it means. which is fun for all of us, but perhaps not that useful.
But anyone against whom a claim is going to be made is going to, who's trying to get out of such a claim is going to have to face the notion that, well, it's better that individual tenants get hit with the burden than the person who did it in the first place, which is not a very attractive argument.
No, it's not. But I have to say, I'd be very surprised if there are that many developers who are still around, because even the big developers build through SPVs, and you wind your SPV up as soon as you finish the development. I mean, that's how you protect yourself. And if I acted for any developers in this field at the moment, I would be making sure that I only used SPVs, and I would be making sure that SPV ceased to exist.
Although given the retrospective extension to the limitation period, it may catch some out. Okay, can I move on to another question, and then I'll ask one of David, but it's apparently there are a number of tenants seeking on 54 Act renewals, seeking an adjustment to the rent clause. And want to make the rent, any rent review, dependent upon approval by the NHS trust funder, so that the rent is limited to whatever the NHS trust is willing to agree to. Now that might be an issue which you both may wish to comment on, but I suspect, Justin, your view is going to be rather influenced by the fact that the NHS trust funder may not be seeking to give effect to the provisions of the 54 Act in terms of fixing the rent.
Quite possibly, yes. I'd be interested to know what David thinks about this one as well. How this fits in with the broader funding regime.
This is very difficult because it's this is a circular problem, isn't it?
Mm.
What do you start with, the lease or the rent? When the rent, this is a variation of the issue that I was looking at into how do you fix the rent for a building which can only be used for GP practice, when you're supposed to ignore the fact that there's only one funder of the GP practice, namely the premises cost directions. In practice, because almost all almost all leases now are in connection with GMS contracts. The answer is, I'm afraid I don't know offhand. I need to go away and think about it and put a wet towel on my head. But my instinctive feeling is that it would attract 54 Act protection, because it would be treated as a lease, even if it was a rent to be fixed, in a sense, by agreement between the landlord and the tenant, by a mechanism which, in effect, fixed the rent by a third party. So it's a bit like having an expert determination clause, which says, you know, here's the lease. You and I agree that the rent will be fixed, maybe for this period to start with, and then after 5 years, by some process of expert determination. It's a sort of variation on that, but I'm not absolutely sure. That's kind of where I think would go, but I need to think about it much more carefully. I don't, Justin, if you agree with that.
I don't know about you, Justin. I'd be rather surprised to have an NHS funder treated as an expert in that sort of way, particularly with regard to fixing of something that's supposed to be a market rent.
Yes, I'm not sure the NHS is going to be the expert, are they? But there's a lot to think about in that one.
In the end, by the tribunal, sorry, by the adjudication process, by the NHSLA adjudication process, that in turn would take its own surveyor, but that's how it's done.
Yeah. Yes, I think that's tricky. I don't think we've got a clear answer to that, do we? David, can I shimmy into another question, which arises out of what you were saying about Sivolsky and premises cost reimbursement? We're asked that in a PMS contract that's silent on rent reimbursement, whether rent reimbursement should automatically be applied.
I think that would involve looking at payment provisions in the contract as a whole, because there are two options in these circumstances. Option one is that the parties intended a global sum to be paid for the provision of the services, and all of the costs to the GP practice of providing those services are rolled into the global sum. And there are a number of contracts such as that. The alternative is that, although it doesn't say so in the contract, everybody accepted that even though it's a PMS contract, by implication, because there was no sum involved for premises, that you'd apply the GMS rules, and therefore you'd be able to reclaim under a PMS contract whatever the GMS equivalent would have been by applying the 2013 directions. And in some ways, this is one of the issues that arises in the Savolsky case, was what was the implication. But in doing so, what's interesting is one applies standard contract implication law, not special NHS law. And one of the issues in the NHS tried to run in the Savolsky case was in effect rectification of the contract, because they said, well, it's plain that we only ever intended this, and therefore it was some
unilateral, an attempt at unilateral rectification.
Both parties really intended the high rent to only continue as long as you were paying the high interest rate, and therefore we want to rectify the contract. And as everybody who's been involved in any of these cases knows, rectification is a very narrow door, and you need really good external evidence to show that's what everyone really agreed. Frankly, it wasn't there. So the answer to the question, it goes back to saying it all depends on the terms of the contract, and whether in fact the global sum was supposed to include the premises costs, or the global sum wasn't ever intended, and the deal was always, even if it's not stated, that you get the GMS premises costs on top. And I must confess, I have seen both on multiple occasions, and it all depends on what the arrangements are. But it's bad drafting by the lawyers if they do a PMS contract which doesn't provide any premises costs, and they don't say which side of the line it goes. That's what you pay your solicitors for, and barristers, to make sure that you don't end up with those type of loose ends, where more than a loose end, a big issue that's simply not addressed in the contract. The default position, of course, is that if the contract says nothing about premises costs, you don't have the right to make any claim for premises costs.
Yeah. So,
because you're paid by a service.
Yeah, and I mean, given that these are contracts drawn up with the assistance of lawyers, you face the normal uphill struggle of demonstrating a case for implied terms.
Exactly, and again, the implied term argument was run in Savolsky and failed for exactly those reasons. If anyone was interested in the case, I actually think that the first instance judgment by Miss Justice Leggett is a much better judgment than the Court of Appeal judgment, because the issues in front of Leggett they ran everything in front of Leggett, and therefore he had the opportunity of commenting on all of these points and produced typically a very, very clear judgment. And by the time we got to the Court of Appeal, the issues were, Jonathan Swift came on board for the NHS, and the issues were very, very narrow, because he ditched all the bits that frankly were unarguable.
Good. Well, I think we've probably covered the questions we've asked, and it's 6:15, so I think it's a good time to draw stumps. Can I thank everyone for attending, and can I thank you both for your interesting presentations and for the discussion on the issues that have been raised. It just remains for me to say thank you to everyone, and good night.